Lordship will take up. There is a petition which has been filed before this honorable writ petition, my lord. We are challenging the notification issued by the state government, SOP, in respect of a bullfight and bull. This is in respect that we have come up before this court. And there is a notification which issued that the date has been given 15 to 24. Today is the last date. 15 to 24, we can hold that fight. But today being the last date, I don't know what. But further, they will go ahead with some other events. This is what we are apprehending. And which, my lord, there are judgments of the Supreme Court. Three states has amended it. That's a different altogether. The judgment of the Supreme Court in 2023, my lord. So now they have amended because the Central Act is there. So you have to follow the Central Act. Central Act, how to protect Wildlife Protection Act. There is a provision how to protect it. So the Supreme Court ultimately 5 judges says you can do it. State has to amend it. Otherwise, it goes beyond 254 miles. That's the whole difficulty. I don't know whether your lordship will be able, but being the date is 15 to 24. Today is the last day. For holding the events, for holding the events.
Today is 25th.
25th, 25th, 25th.
Hmm.
So tomorrow is there is no court. And এইটো কেতিয়া ওলাব আৰু এটা আছে যে এই ডেট নোটিফিকেশন they want to bring it. But in case of Buffalo, they said that they have given a date in pursuant to notification 15 till 24, 25, 24. That's the whole difficulty. But if the state amend, they cannot replace it by way of a notification.
So whether today it will lapse.
Today, because 25th is tomorrow anyhow, it's a holiday. But Bulbul, my lord, in a year, I know that's in
Can it be immediately after Monday? Monday?
Monday is 29. After Monday. Your lordship will pick up Monday, party? 30th? No.
30.
Okay. Only my apprehension is they will let them do it.
They may extend it.
They in some other events they can again. They can
Otherwise, validity is up to today.
Validity in so far as that. But today I have come to know there is some notification again, not notification. Some other party has said that they are also organizing some bullfight. So that is, my lord, the government has issued an SOP which challenge that. That is for 15 to 25th, which your lordship today is 25th is tomorrow is a bit difficult.
Yes.
But today they said, my client said that you have to come with an IA providing the details to the court. So then court can look into it. How they have. So we may bring an additional affidavit bringing notice to the court.
Writ petition is pending or?
Writ petition we have filed it today itself.
Okay, okay.
Yes. Yesterday we have filed it.
Let it be on
But it is
29 or
not
30,
numbered.
whenever you want.
29, 32 can easier. 30, 30 minor.
Okay, 30. Mr. Das, submit a mention memo.
I am deeply obliged, man. I told because today is expired,
Yes.
so that will be a bit difficult.
If it is it will lapse today, then it is difficult. But it is
we want-
extended, then it will be alive again.
But we challenge the notification. That can be decided, that notification.
Okay.
Very please, sir. My lord, in respect of item number 11 and 12, my lord, there is a joint prayer, my lord, from both the parties. My lord, this matter, my lord, 11, 12, respondent is also the Tinsukia Development Authority. My lord, it may be taken after 3 weeks. Thing is that, my lord, some outside the court also may be civil.
Okay. Mr. B. Borua, Council for the Petitioners, and Mr. R.S. Mishra,
My lord, for respondent number 5 and 6, my lord.
correspondent number 5 and 6. Have finally submitted that some discussion is going on outside for outside settlement. So they have submitted, come out with the consent of the who is the municipal board council?
Yes, my lord.
Oh, you are. Okay. Mr. Goswami? Mr. Goswami and Goswami Learned Council for the State Respondents is present in view of the joint prayer made by the Learned Council for the parties. laid back cases after trips.
May it please your lordship. May I pray for listing of a motion? 29.
May I please, I beg to mention item 9, Lordship. I have taken consent from the other side and yesterday submitted the adjournment. So
Okay.
may I,
Mr. H. Chetri,
on behalf of the PD Nair. His
Learned counsel appearing for Mr. P.D. Nair.
Lordship.
He is counsel for petitioner.
Yes.
Learned counsel for the petitioner has paid for listing of the case after a week,
After any date will be fixed.
after 2 weeks.
15th of February.
Let the race decide, will say, after 2 weeks, for hearing. Also, it is submitted that consent has been taken from the learned counsel for the respondents to make the prayer.
Obligations.
May I please your lordship, my lord? My lord, I have prayer for listing of a case, my lord, regarding land, my lord, eviction matter, my lord. This was filed on, my lord, day before yesterday, my lord. May I pray before your lordship, my lord? Kindly take up this matter after 2 p.m., my lord, if possible, my lord, today, my lord.
Why? We have many things because of the Republic
Yes,
Day
my lord,
also.
lordship will kindly bear with us, my lord.
What is the notice? What is the notice?
My lord, notice was issued, my lord, in some other person's name.
When notice was issued?
Notice was issued, my lord, in the month of December, my lord.
December, you are waiting.
I have received, my lord, just, my lord, 3-4 days back, my lord. That is the difficulty.
29.
My lord.
May I please, your lordship? I beg to mention for listing of the matter for motion, your lordship. Any date next week, your lordship. Okay. Pleasure.
To mention a WPC
For listing, your lordship. Actually, the urgency is that our license was cancelled in 2021, your lordship.
No urgency next week.
No, your
After
lordship,
1 week.
we are not being able to
No
supply
urgency,
food.
already cancelled.
Kindly fix it at 30.
Next week.
Much obliged.
Next week probably.
May I please, lordship, I beg to mention to read petition pending matter, lordship, already read petition pending matter for admission. Already this matter was fixed, but due to leftover, was fixed on 8/11. And
Yes, I ordered.
kindly matter may become on 2nd of February, lordship.
No, not second. Court master will give a date.
May I please, your lordship, I beg to mention for listing of a matter for admission hearing. Last time it was listed for admission, but due to some unavoidable circumstances.
Subject,
The matter is pertaining to demarcation, my lordship.
file application before the registry. Demarcation. Yes,
May I please, your lordship? Lordship, I beg to mention a writ petition for admission matter pertaining to ex gratia, your lordship. And
file an application, which is not such
lordship,
urgency.
22 matter, lordship.
File an application before the registry.
May I please, your lordship?
Yes,
With the consent of the other side, I beg to mention item number 8, lordship.
8.
Lordship, due to personal difficulty of my senior, kindly adjourn the matter for today.
Who is your senior?
S. Chauhan.
Because on the previous date also it was adjourned perhaps. It was observed that since it is of 2014. One adjournment was granted.
Yes, lordship.
Again, you have come up for. I take it, man. Okay, Miss. Your name?
R. Dev.
R. Dave Learned Council. Appearing for Mr. S. Soha,
Yes.
Learned Council for the petition. Has paid for listing of the case after 1 week. Full stop. As the petition is of the year 2014. Though the prayer is granted, release the case on 1/2/2024, as the petition is of the year 2014.
Much obliged, lordship.
For withdrawal, item number 13.
Yes,
My lord, during pendency, my lord, the respondent authority has rejected the claim of the petitioner, so we have to challenge this.
Mr. M. Hussain, Learned Counsel for the petition,
Liberty may be given.
has submitted that the petition wants to withdraw the petition as a new cause of action has arisen. New cause of action.
Yes, rejected the claim of the
So
petitioner.
new cause of action
Yes, my lord.
in view of the above submission, Mr. N. Goswami, sorry, S. Borwa, Z. Hazarika Likhit Revenue 1 আৰু S. Borwa, Junior Government Advocate are present in view of the above submission made by Mr. Hussain, Learned Counsel for the petition. The petition is dismissed as not placed. With the liberty to the petitioner or selling to approach again.
Motion item number 14. When challenging the so-called notice, my lord, what happened here, my lord, on same set of facts, my lord?
Hmm?
On same set of facts, on same subject matter, my lord, two proceedings has been initiated, my lord.
What was the first one?
At page 20, my lord. Before that, I will not.
Page 20.
Page 20. Before that, I will not like to take up page 18, my lord. Page 18 is the intimation given by the central GST authorities, my lord. And page 19, my lord, they say if you do not respond to this intimation, they will issue a so-called notice, my lord. Last.
You are advised to pay the amount.
Page 19, last paragraph, my lord.
19 last.
Last, my lord.
Failing which so goes notice.
Thereafter, my lord, it was issued on 29/11/22, my lord. Then,
This
my lord,
was this notice was of which date?
29/11/22.
29/11/2023. Okay.
Thereafter, my lord, page number 20, my lord. State GST authority issued a so-called notice, my lord, on 1/12/23, my lord.
1/12/2023. Okay.
My lord, center was proposing to issue so-called notice. In the meantime, state has issued, my lord.
Hmm.
That is at page 20, my lord, and we have responded to the so-called notice also, my lord. Our reply is at page 26, my lord.
Yes.
Thereafter, my lord, at page 35, my lord. Center issued a proposed notice, my lord, for the same period, same figure, same issue, my lord. Page 35. It was issued on 27/12/23.
Let us compare.
My lord. Which may see the figures at page 21, my lord.
21.
My lord, page 21.
Hmm.
The my lord, the tax in dispute is 1,46,41,235, my lord. At
21.
column number 8, my lord.
Hmm.
And lordship will see the notice of center, my lord, page 35, my lord. Paragraph 3, my lord, value is same, my lord, 1,46,41,235. And my lord, allegation is also same, my lord. The allegation is a violation of section 16(4), my lord, of CGST Act, my lord.
Yes, Mr. Kayal.
I'm relying upon section 16, subsection 2B of CGST Act, my lord.
16.
Sorry, Lordship, section 6, subsection 2B, my lord, which bars, my lord, simultaneous proceeding, my lord.
Section 6.
Subsection 2, subclause B, my lord.
Section 6. Subsection 2.
2, subclause B, my lord.
When page 20 was issued?
So, issued on, my lord, 12/23, my lord.
And when page 30 was 30,
35, my lord, it was issued on
35.
27/12/23, my lord.
Yes, overlapping of jurisdiction it appears.
Lordship, apparently, privacy. Lordship may take upon, after a week, in the meantime, I'll obtain instead.
Because it appears to be in violation of
Yes, Lordship, apparently.
Prima
And
facie.
Lordship, they've submitted one representation to the central authority, page 44.
You find out, meantime, don't. If you take a call on your own, okay. Otherwise, we will take a call.
Not,
Heard Mr. R.S. Mishra. Counsel for the petition. Mr. Gogoi, you appear?
Yes.
MSK Pukon, Land Central Government Council, for the respondent number 1. Mr. S.C. Kyle, Learned Standing Council, CGST,
234.
for the respondent number 2, 3, 4. And Mr. B. Gogoi, Learned Standing Council, Finance and Taxation Department, within brackets SGST. Otherwise, for the respondent number 5 and 6. The petitioner who is a registered assessor under the Central Goods and Services Tax Act 2017, stroke State Goods and Services Tax Act 2017, with GST registration number, there are 3,000. Full stop. Alleging a violation of the provisions containing section 16(4) of the CGST Act stroke SGST Act. CGST Act. Petition was, the petitioner was served a notice in form ZSTDRC 018 dated 29/11/2023. Stating that the petitioner had wrongly availed input tax credit, right?
My lord.
ITC for the period from June 2018 to March 2019, amounting to rupees 1,46,41,235. Also by the same notice in form GST DRC 01A. Who is the respondent for 18?
Respondent number 4, my lord.
The respondent number 4 by the same notice advise the petitioner to pay the said amount of rupees 1,46,41,235. The said notice was followed by a show cause notice dated 1/12/2023.
My lord. This proposal 1/12/23 was issued by state GST authorities, and this intimation was issued by central GST.
No, page annexer B is by
Central GST,
annexer respond number 4,
my lord.
meaning thereby he is CGST authority.
My lord.
Immediately on the
My lord.
after 2 days, it was followed by this SGST notice, so cause notice.
Yes. Yes. Sorry, ma'am.
So cause notice, not followed by so cause notice dated 1/12/2023 from the respondent number
My lord.
6. Alleging similar violation. Similar kind of violation. That is, violation of provisions of section 16(4) of the CGST Act, stroke SGST Act. And the petitioner was asked to show cause as to why. The input tax credit amounting to rupees 1,46,41,035. While alleging that the petitioner had availed input tax credit to the extent of rupees 1,46,41,235. On receipt of the notice, so-called notice dated 1/12/2023, the petitioner submitted his reply to the so-called notice on 30/12/2023.
It was uploaded on 31/12, page 34, my lord.
Within bracket uploaded on 31/12/2023. When the proceedings initiated by the so-called notice dated initiated by the SGST authority by the so-called notice dated 1/12/2023. The petitioner has been served another so-called notice. Page 35.
35, my lord.
Dated 27/12/2023. Issued under the hand of the respondent number 4 for the for violation of the provisions of section section 16(4) of the CGST Act 2017, and the petitioner has thereby been asked as to why the petitioner has been asked to show for the petition by the said notice. It has been alleged that the petitioner has availed and utilized an amount of rupees 1,46,41,235 wrongly as input tax credit wrongly, which Mr. Mishra and a counterpart of petitioner was contended that once the proceeding has been initiated by the SGST authorities by the show-cause notice dated 1/12/2023, the CGST authorities could not issue a show-cause notice on 27/12/2023 on the same subject matter. So such an action is in violation of the statutory prescription contained in subclause B of subsection 2 of section 6 of the CGST stroke SDST. Post of Mr. Cal Lanet, Planning Council. CGST has sought for some time to obtain instructions in the matter, as the petitioner against the show-cause notice dated 27/12/2023 has filed a representation before the CGST authorities on 8/1/2024. He has submitted that he will obtain instruction as regards as to whether any decision has been taken by the CGST authorities on the same representation dated 8/1/2024. Post of issue notice. Will issue notice, or we can ask for your, we can wait for your instruction.
Lordship may fix on 7th, I will.
Okay, as Mr. Cal has thus sought listing of the repetition case on 7/2/2023, having regard to the materials on record, two so-called notices, and the provisions contained in subclause B of subsection 2 of section 6 of the CGST stroke SGST, comma, and the respondents CGST authorities shall not proceed further in terms of the so-called notice dated 27/12/2023 till the next date.
Much. Before admission, item number 1 to 7.
7, okay. Hello, 7. 1 to 7. Okay. Okay, over there.
But before the others start, well, let them start the hearing today. As far as the respondent party is concerned, the advocate general will appear. He will be making submission on Tuesday, if not convenient to this one.
Tuesday.
Otherwise, let them start.
Tuesday cannot be free. Because
Yes,
Monday and Tuesday, this court will only sit for the first half.
Got it.
Many matters are fixed on Tuesday. So far, if it goes down to Tuesday.
On 6th,
It's for cannot be free. Maybe next date, we don't know, we'll fix,
Yeah.
but not on 30th. We can start today, but next date should not be on 30th. We'll be rising at 1 o'clock,
Well, next date may be
Monday and
after.
Tuesday,
After.
and many matters are fixed. It is your call now.
Well, I'll start.
Similar matter,
No, the issue is the same.
facts are to be adverted to in each of the case or not?
Yes, slightly.
Just
some
to,
provisions
just to
are-
understand before proceeding.
Main facts are the same, but the ultimate order here and there, I will just place the difference, whatever is there subsequently. But the main issue is the same in all the cases.
Prayer was for refund, that has been rejected by the Commissioner of Taxes by issuing separate speaking orders in all the.
But the orders are exactly the same.
Dealing with one order will do or dealing with
One order will do.
all the 7 orders?
No.
Because if the issue is common,
The issue is only whether the petitioners in this case, in this series of cases, are entitled to the reimbursement of the central state tax in view of section 15B of the Central Sales Tax Act. The issue is all in the same.
dealing with one order will
My lord, yes.
Yes,
Cover.
otherwise, yes, but provisions under which this order for reimbursement has been made by reassessing the entire issue. That provisions are different.
I'll place the 20 if necessary. You'll also will
Some
do-
has been carried out under section 42 of the VAT Act. Some has been under section 83. Some has been under section 36(1) of the VAT Act. Though the main objective was to reimburse. So we'll point out, So by finding all these anomalies, finally the Commissioner of Taxes passed a speaking order separately in all assessment years that they are not entitled. He has given some grounds.
Well, whether section 42, whether section 32, 37, or whether whatever section he's
Yes.
saying, the question is that, the issue arises is whether the Commissioner of Taxes has
fact
any.
of the matter is that I am not aware of any of the provisions you have made.
No, I've placed it,
No, I'm just pointing on.
So I'll start with 0.
But the issue will be there, whether the Commissioner of Taxes has any power in jurisdiction. to
Okay,
reflect-
let us proceed with one and
Manu, you also may start with 6864, item 1.
6864.
I have to give the little background of the case because the issue is started long back in the year 1971 first.
Yeah. Yes.
When the Central Sales Tax Act 1956 was enacted, Section 14 of the Central Sales Tax Act,
Central sales tax.
my lord,
No, Econ
Section 14,
sales tax. Act. Pasang yang masuk kali ini saya. Yes.
this section was repealed with effect from 1/7/2017, the day the GST,
Repeal from 1/7.
my lord. After the introduction of the GST. my lord.
Okay.
Now, prior to repeal, I think the bottom middle also you'll find this earlier section below. Prior to his repeal,
Certain goods to be
My lord.
special.
my lord. Certain goods to be of special importance in interstate trade and commerce. It is hereby declared that the following goods are of special importance in the interstate trade and commerce. You see, IEA, my lord. Clause IEA,
IA.
my lord. Coal, including coke in all its forms,
Coal.
but excluding charcoal.
Oh, yes.
You said, coal, including coke in all its forms, but excluding charcoal. Now, the petitioners in this case are the manufacturers of calcined petroleum coke.
Calcine.
Petroleum coke.
Yes.
This calcined petroleum coke is manufactured from raw petroleum coke, which is supplied by the various refineries in the state of Assam. The petitioner purchases raw petroleum coke from the refineries, and after processing manufacturing, the calcined petroleum coke is manufactured.
What is raw petroleum coke?
Raw petroleum coke.
Yes.
Now we'll also make analysis 15 of the Central Sales Tax Act, more particularly section 15B. What does it say? This was also repealed from 1/7/2017.
15B.
B. Small b,
Okay, 15 small b.
my lord.
is 15. 15.
Obligation, condition, responsibility for judgment, location, Supreme Court.
Okay, read from 15 to 15B.
15B, my lord, I mean,
But before that, the main part,
my lord,
so that I'm
my
sure.
lord, my lord.
Ah.
Restrictions and conditions in regard to tax on the sale or purchase of declared goods within a state.
Declared goods.
Declared goods, section 14, my lord.
Okay. Okay. Declared goods.
My lord.
Coal including coke is declared goods
My lord, coal including coke in all its forms.
as per section 40.
14. There are various items. One of the item is coke, coal including coke in all its forms.
All each. Okay. All each. Six text. Yes, section 15.
15, my lord. Now, A says, my lord,
Every sales tax
law of a state shall, insofar as it imposes or authorizes the imposition of a tax on the sale or purchase of the declared goods, be subject to the following restrictions and conditions. Now, one of the conditions A was that, my lord, the tax payable under that law in respect of the sale or purchase of such goods inside the state shall not exceed 5% of the sale or purchase thereof, price thereof. So the first, earlier it was 4%, Lord. So the first restriction was that the tax rate cannot exceed 5%. Now, second one, B is important, Lord.
Yes.
Where a tax has been levied under that law in respect of the sale or purchase inside the state of any declared goods, and such goods are sold in course of interstate trade or commerce, and tax has been paid under this act in respect of the sale of such goods in course of interstate trade and commerce, the tax levied under such law shall be reimbursed to the person making such sale in course of interstate trade and commerce in such manner and subject to such conditions as may be provided for in the law in the state.
Wait, taxes will leave it.
Was it?
Does it indicate that where tax has been levied
My lord,
under state law
my lord,
in respect of sale and purchase inside the state
my lord,
of any declared good? That is one part.
my lord,
Then second stage, if such goods are sold in the course of interstate trade or commerce
my lord,
and tax has been levied, paid
paid,
under this act
my lord,
in respect of sale of goods in the course of interstate trade or commerce, that means second time.
CST Act,
Second time.
my lord, under CST Act,
Second time tax levied.
my lord,
Then the tax levied under such law shall be reimbursed.
my lord, the,
Is it the correct position?
my lord, I may just say, my lord, if the tax has been levied under the state law,
State law.
my lord, in respect of the sale and purchase of any declared goods inside the state, and such declared goods are sold in course of interstate trade and commerce, because interstate trade and commerce is governed by the CST Act. In case they are sold in course of interstate trade and commerce, and tax is paid under that law, that means under the CST Act, then the tax which has been levied under the state law shall be reimbursed to the person making such sale. Well, there are four conditions are to be fulfilled.
Retail tax of the states that so far as it was authorized for the imposition of tax, the sale or purchase of declared is subject to the following restrictions and conditions. The tax is levied under that the state on declared. Reset. Reset. Tax levied under state law
My lord,
is to be reimbursed to the person making such sale in the course of interstate trade or commerce in such manner and subject to such conditions
at my best.
as may be provided in any law, means state law,
Law.
in force in that state.
My lord.
In that state means say
That's the
Assam.
state from where, my lord, the goods are moving.
Hmm.
Like I get the reimbursement of Assam, tax, so the Assam law.
So you shall be reimbursed to the person making such sale
What are the
in
five?
the course of interstate trade or commerce in such manner. So it is laced with two conditions.
Like, my lord, there are five conditions, my lord.
Oh, no. ABC, no. Within B. Within B, in such manner and subject to such conditions.
That is, there is no difficulty, my lord. The first is that, my lord, there must be declared goods as per section 15B. Secondly, tax must be levied under the state law on the sale and purchase of such declared goods
Inside the state.
inside the state. So first declare goods, then tax must be levied on the sale and purchase of such declared goods inside the state. Third, such declared goods must be sold in course of interstate trade and commerce. Fourth, tax must be paid on such sale made in course of interstate trade and commerce as per the CST Act. And if the four are fulfilled, then the tax which has been levied under the state law will be reimbursed to the person making such sale in course of interstate trade and commerce, subject to such conditions and the procedures as per the state law.
Yes.
इंडिया का बहुत डिफरेंस पता है इंडिया का 1971 जजमेंट আছে স্পষ্ট মনে থাকে রেফারেন্স পিটিশন কি আছে নিরাপদ বলতে প্রবলেম বলতে গেলে চিন্তা করব না রে This will give the intercarbonated reference in 1971 was first as a petition. '71 or. Yeah. हमारा होता ना जाए इस प्लेस पर
So
Milo.
the good has to be declared as a, has to be declared, is to be a declared good.
Milo.
Then the state law levies tax on such declared good.
Milo.
Thirdly, such goods are to be sold in the course of interstate trade and commerce.
Milo.
Fourth, tax is paid on such goods sold in the course of interstate trade and commerce.
Milo.
Then it would qualify for reimbursement by the state.
Milo. This is the preconditions.
These are the broad.
Milo. Absolutely, no?
Yes. Yes.
Now, in the very first minute, the dispute arose as to whether the petroleum coke is covered by NT 14(1)A or not.
Meaning whether it is a declared good or not.
Whether it is declared goods or not, because it was said coal, including coke in its form.
The dispute is regarding calcined.
Calcine and raw petroleum coke. First of all, whether petroleum coke will fall, although this has been settled now.
Petroleum coke
Coke,
falls under declared good.
declared goods.
Okay.
Now, this was settled by the apex court.
Oh.
I have reproduced, in fact, because that will not be necessary, but at para 18, at page 17.
Era 18. Era 18. Yes, para 18.
By law.
Issue in the form of coke. Or this form, is not petroleum which covered by or
Relevant part, I will take a lossy to page 19, Milo. The last paragraph.
Ah.
We do not consider.
Yes.
We do not consider that when the parliament.
Para 19.
Page 19, Milo.
Page 19. Okay.
The last paragraph.
We do not consider.
We do not consider that when the parliament used the word coke in section 14(1) of the Central Act, it had any intention to give it a meaning other than the ordinary dictionary meaning, which would cover petroleum coke. At any rate, the language employed is so wide, coke in all its form, that petroleum coke, which is the form of coke, cannot possibly be excluded merely by reference to the word coal.
Hmm. Yes.
Now, after this judgment, my lord,
Hmm.
although the law was settled, but again a dispute arose whether, my lord, the calcined petroleum coke and raw petroleum coke, when it manufactured from raw petroleum coke, calcined petroleum coke, whether it will be outside the purview of the anti 14(1).
Whether calcined,
Well, when it is purchased, raw petroleum coke is purchased and calcined petroleum coke is prepared,
okay, whether calcined petroleum coke
my lord.
falls within purview of section
14(1). You want to
14
pay those judgment.
1.
And that issue was also settled by the apex court.
Ah.
And the judgment, my lord, loss find at page 109.
109.
And I take a lordship to directly to page,
CC at 1994.
Hello.
PSCC
my lord.
621. State of Bihar. Universal. Right. Yes,
And I take directly to your lordship, page 114, para 18,
para 18.
my lord.
Para 18. Yes, let us read para 18.
My lord. We are totally unable to accept this line of reasoning. Once the entry is coke in all its forms, irrespective of the fact raw petroleum coke loses its original identity, or in the process of manufacture calcined petroleum coke is produced, cannot take calcined petroleum coke outside the purview of the entry.
Yes.
In more or less identical situation, this court held in India Carbon Limited, petroleum coke is one of the form of coal governed by the expression coal within section 1814(1)(a). The relevant extract is so and so. Now, 19, my lord. This decision fully supports the respondent. The fact that calcined petroleum coke is different commodity is little consequence.
Yes.
So the apex court held, my lord, that when even if the raw material coke is converted into calcined petroleum coke, and in the process the raw petroleum coke loses its original character, nevertheless, the item calcined petroleum coke will fall under section 14(1)(a) because the word is coke in all its forms.
So coke in all its forms
My lord,
includes petroleum coke. Petroleum coke.
my lord,
And within petroleum coke, raw petroleum coke and calcined petroleum coke. Though it undergoes
some
changes
process,
from raw petroleum coke to
Calcined.
reach the stage of calcined petroleum coke, but nevertheless, it is all within the definition of coke. That means section 14(1).
In other words, I mean, similar, that although it may be different commercial commodity, from raw material coke to calcined petroleum coke, it may become a different commercial commodity. But so far as section 14(1)(a) is concerned, it remains the same declared goods,
Declared.
that coke in all response. Now, even after this judgment, my lord,
Hmm.
of the apex court,
Hmm.
the state legislature of the state of Assam, my lord,
1 minute.
my lord, what was the amendment to? What was it? Page? Human page? One was it. Page, into the entry, say.
Yes.
So when the situation was this minute after the judgment of the apex court, the state legislature, Assam state legislature, made an amendment in the local sales tax law. The act was not Assam Sales of Petroleum and Petroleum Products Act. You'll also find page
A
paragraph 20.
specific act.
By earlier, below.
Okay.
You'll also find page 20, paragraph 20 below.
Yes. Paragraph 20. Yes. Okay, paragraph 20. What is this? Sum.
I'm reading below. That in spite of the aforesaid judgment of the apex court, the Assam state legislature by an amendment made by the Assam Sales of Petroleum and Petroleum Products, including Motor Spirits and Lubricant Taxation Amendment Act 1986. The said entry was classified into two different entries which it is under.
One.
Will also see what was the amendment made.
One. This is an amendment act,
This was an amendment act, my lord.
whereby what act was amended or what provision of which
The
act
entry
was
was
amended?
amended, my lord. The entry at the bottom you'll also find.
So it means that there was an act,
Yes.
Assam Sales of Petroleum and Petroleum Products, including Motor Spirit and Lubricant Taxation Act.
That
There
was
is an act.
1955,
1955.
my lord.
Okay. I have heard it for the first time. It is 1955. Okay.
That was amended
Hmm.
by an amendment act of 1986.
Yes.
And in the said amendment, what was done, you'll also see.
Yeah.
Petroleum coke, 4 paisa in rupee. My lord, as I submitted earlier, note the 5 paisa was earlier 4 paisa.
Hmm.
So petroleum coke was made 4 paisa in rupee. And an explanation was added that petroleum coke means raw petroleum coke only and does not include calcined petroleum coke. Thereafter, another entry was made in the next page, Milord. The calcined petroleum coke 4 paisa in rupee.
That was prior to that universal hydrocarbon.
My lord,
case.
my lord.
So earlier entry was what?
Petroleum coke,
Only petroleum coke.
my lord,
So previous entry, petroleum coke.
my lord. I just
Petroleum
confirm it
coke.
again, my lord, as your lordship asked the query. As your lordship asked the query, I will also confirm, but it was must be petroleum coke. I will give it.
Because it is stated that classified into two different
My lord,
entities.
my lord.
So classified into two different entities. One is petroleum coke. Petroleum.
My lord.
Basically, it includes only raw petroleum coke.
Obviously, my lord. This was only to deny the reimbursement of section 15B of the central sales tax law.
And next one is classified as calcine.
Calcined petroleum coke.
Calcine. Petroleum. Coke. Okay.
My lord. Now, earlier there was 14A, there was also restriction that the same commodity can be taxed twice. So both the restrictions, they made petroleum coke, raw petroleum coke and calcined petroleum coke. Whereas your lordship has seen in the India Carbon case,
Petroleum coke plus raw petroleum coke, they would get the benefit.
they will not get the benefit, my lord, because
No. Calcine will not get.
because the raw petroleum coke is purchased and raw petroleum coke is only sent, then only they will get the benefit. Because what they did, my lord, that any industry which is there in Assam, manufacturing calcined petroleum coke from raw petroleum coke, they are purchasing raw petroleum coke from the state, manufacturing calcined petroleum coke and sending calcined petroleum coke to outside the state. Now, as per the Supreme Court decision,
By Supreme Court decision was of 1972.
72,
There it was said,
both are included.
both
The calcined petroleum coke is also included.
which cover petroleum. There the discussion was petroleum coke.
My lord,
There the discussion was petroleum coke in 1972.
my lord,
So in 1986, what they did is petroleum coke has been divided into two.
my lord,
One is petroleum coke,
my lord,
which includes raw petroleum coke.
absolutely.
And other one is calcined petroleum coke. And it says that calcined petroleum coke,
A different commodity.
different commodity. Then after 8 years, in 1994, Supreme Court explains that both are same.
Both are the same. Now, this amendment was made. Now, but result of this amendment was that, my lord, all the calcined manufacturing units which were there in the state of Assam, we were purchasing raw petroleum coke within the state, and the local tax was paid, and the calcined petroleum coke was sold in course of interstate trade and commerce, and the tax was paid on the calcined petroleum coke. They were denied the benefit of the 15B on the ground that what was purchased and what was sold was not the same declared goods.
So since from and on 1986, the entities dealing with calcined petroleum coke started in disadvantage, continued in disadvantage. So sigh of relief was in 1994.
No, prior to the Guwahati Act, this Honorable Court also granted the benefit. No, this was challenged. Before-
86 amendment was challenged.
Challenged
Okay.
before this Honorable Court.
Okay. 86. Amendment was changed. Okay,
And page 102,
page 102.
the division bench of this one.
Hmm. 102. 10. Nine. Page 102. 1992. 1 GLR 82 PE. Search here. Carbon. Okay,
Now at page 107,
107.
this was division bench, para 10.
Yes. Para 10.
My lord.
Yes.
My lord. As stated earlier, clause A of section 15 imposes restrictions on the sales tax law of the state. That the state law cannot impose tax on the sale or purchase inside the state of the declared goods at more than one stage. It has already been concluded that raw petroleum coke and calcined petroleum coke are goods declared, and they are to be treated as one and the same for the purpose of item 1A of the Act under section 14 of the Central Act. Therefore, although Assam Act has treated the raw petroleum coke and the calcined petroleum coke, which are goods declared as different commodities for the purpose of sales tax law of the state, the treatment of the two different commodities cannot prevail over the section 14 of the Central Act. This being the position, if the raw petroleum coke is purchased inside the state and the calcined petroleum coke is also sold inside the state after calcination, and if the state law imposes tax on the raw petroleum coke as well as the calcined petroleum coke, it would be imposition of the tax on the sale or purchase inside the state of goods declared at more than one stage, which is not permissible under clause A of section 15 of the Central Act. In that view of the matter, Assam Act cannot impose tax on the raw petroleum coke as well as the calcined petroleum coke if the sale or purchase of the raw petroleum coke and the calcined petroleum coke takes place within the state of Assam. As such, imposition of the tax will be unconstitutional in view of the Act. And so under Article 286, 1 of the Constitution read with Central Act. We are therefore of the view that the doctrine of reading down shall be attracted in the present case in order to save unconstitutionality when such a situation arises, and that in terms of entry 7 of clause 1 of section 3 of the Assam Act, if the words namely which was not subjected to tax as raw petroleum coke are added within brackets after the word calcined petroleum coke, it will save the classification from being unconstitutional. Accordingly, we read down the entry as below. Now, what was entry below? Calcined petroleum coke within bracket which was not subjected to tax as raw petroleum coke.
What is this reading down? One.
One remain the same. And two-
Entry 8. Entry 8 of clause 1, section 3. Crossing the words, namely, which was not subjected to tax.
That means, my lord, although the two entries were made in the Assam Act, the raw petroleum coke and the calcined petroleum coke, the petroleum coke and the calcined petroleum coke, this Supreme Court held at them, my lord, that calcined petroleum coke can only be taxed if it was not subjected to tax as raw petroleum coke. That means if raw petroleum coke was purchased inside the state and the tax was levied, then calcined petroleum coke cannot be taxed. If raw petroleum coke, assuming, my lord, I purchased calcined petroleum coke from outside the state,
Raw or calcined.
calcined, and the same was sold inside the state,
Same was sold.
sold inside the state. Then since the raw petroleum coke was not taxed inside the state, thereby you will be liable to pay tax on the calcined petroleum coke. But in case you purchase raw petroleum coke inside the state, by paying the tax, then the calcined petroleum coke again will be taxed. This was to save the entry from being conflict with section 14A, read with section 286, article 286, 1 of the Constitution. Now we may come to para 11 below. May I read? Hello?
Para 11.
11.
Yes.
With regard to the refund of tax under section 15B of the Central Act, clause B provides that if the same declared goods are subsequently the subject matter of the interstate sale and tax is paid on such transaction under the Central Act, then a dealer will be entitled to refund of tax paid under the state law. As stated earlier, the raw petroleum coke and the calcined petroleum coke are declared goods and are to be treated as one and the same for the purpose of clause 1A of the list under section 14 of the Central Act, and that the treatment of such declared goods as two different commodities cannot override the Central Act. Therefore, to contention of the learned advocate general, that there are two different commodities for the purpose of sales tax law of the state, and that tax paid cannot be refunded, has to be rejected. For these reasons, the petitioners are entitled to refund in those cases where tax has been paid on the sale or purchase of petroleum coke under the Assam Act, and tax has been paid on the sale and purchase of the raw calcined petroleum coke under the Central Act.
Yes. Subject matter of challenge was that reclassification.
Reclassification. Now, an SLP was preferred against the state judgment of division bench. And when the SLP was pending,
Yes, SLP.
madam,
This was in 1992. Okay, SLP.
that was pending. During
Hello,
the
pending.
pending before the apex court at that 11 time, my lord.
Okay.
Now, when it was pending, there was another judgment which came from the apex court, which you'll also find at page 109. 09 নহয় আগতে যি দিছিলো কোনটো আছিল এইটো next floor. I'm sorry, my lord, this is, you lost you 116, my lord. 116 which starts, no? Right. What was it? I didn't have this, no? Copy as in the source copy.
116.
I'm just giving copy, I think. That copy as in the it doesn't make it Supreme Court as it as one.
Do you have a copy of this Assam sales of petroleum and
Give the copy, my lord. In fact, I also missed it, my lord, fact. I will
just
give
to have a look?
No, no, I'll give the copy, my lord.
Reported
Which one, my lord?
that when SLP was
My
pending,
lord, SLP was.
another judgment came.
Well, I take your lordship to the dismissal order, my lord.
No. You just said that when
There was a.
that SLP which was
I think-
preferred
I think
against the
one of the-
DB judgment was
Well, I
preferred.
think this judgment was, the Supreme Court relied on this judgment, my lord. What was it? Simple है तो Supreme Court judgment is 2017 or
Page 109.
मतलब पंजीकरण I think I placed before that
129. 129.
129 episode as it state of we have elected 12 को कैसे elected 12 मिलो 109
But I think that is this is a judgment
well in fact it I mentioned
because I pointed out earlier because at if you see your repetition,
my lord
So the next one.
next thing all the minute paragraph 23 paragraph 22 page 23
para
22 page 23
1 minute.
पूरा इंडिया का
Oh, I think one. Because one paragraph you also quoted earlier, paragraph 19.
my lord that was state of Bihar my lord
Same, paragraph 22.
paragraph 22 my lord I'm writing my lord that the SLP was dismissed following that judgment
No, in paragraph 19, same universal hydrocarbon.
my lord my lord
And you missed that because one supplementary was in paragraph 19. In paragraph 22, that supplementary is missing.
that is now the 24(3) SCC my lord that is I think supplementary will be there
Supplementary should be there or not there?
my lord check up my lord I know
Oh, it is there.
supplementary
109. Supplementary is there. 109.
it is mistake my lord I'm sorry
Because of quoting the same judgment in paragraph 19 and paragraph 22,
some confusion
some confusion got. Okay, this came.
my lord
109, page 109 judgment came,
my lord
right?
now this SLP which was preferred by the state of Assam
1 minute, 1 minute. I think this is the sequence. Para 19 is Yes.
Now that
In
is,
1994, that is
now that
in
is,
1994, that is petroleum coke, raw petroleum coke and petroleum, calcined petroleum coke. Even it undergoes manufacturing process.
it remains the same declared goods.
Ultimately, it is under coke in all its forms, declared goods under section 14.
Now, following that judgment, the apex court dismissed.
So SLP would be, the likely fate of the SLP would be dismissal.
That has been dismissed. In fact, the
Where is
order,
that page?
well, the order has not been yet, I will provide the copy, but I will
Okay.
make the statement at page, I bring in the copy below,
Okay.
at para 22.
Okay, SLP against DB judgment was dismissed.
My lord.
When?
Why?
Any idea?
22/9/1995.
Was dismissed on
22/9/1995.
1992. I think I have seen here just while I was going through somewhere, perhaps on the basis of hydrocarbon, universal hydrocarbon. You have annexed somewhere. I was just now I have seen it. If it is it 128?
128 is.
No, come to 129. The issue involved in this appeal is squarely covered by the judgment of this court.
That is another round.
Huh?
128 is another round.
And okay. It was dismissed on 22/9/1995. Paragraph statement.
Paragraph 22.
Paragraph 22.
And I will provide the copy just now.
Okay. Okay.
Now, my lord, when the things were moving like this, in certain cases, the refunds were also granted on the to other dealers and all those things. Suddenly, the refunds were again denied. And they denied on the ground that there was a Supreme Court decision, larger bench, which said that if a declared goods, like in the entry, you will also find 5-6 items are there. In many cases, you will also find 5-6 items are there.
5-6 item back.
In one line, you'll also find the items are there, number of items are there. Like we may see the iron and steel,
Iron steel.
my lord,
Roman 4.
Roman. Who,
Small Roman 4.
my lord, and just, my lord, yes,
At the bottom,
my lord,
page 28.
my lord. That iron and steel, that is to say, number of items are there.
Big iron. Okay.
So the apex court held, my lord, that if we declare goods from one item to comes to the another item, then it is different declared goods. Then it becomes a different declared goods.
Meaning thereby?
Like from one, the item manufactured comes to two. After manufacturing, it becomes two.
Okay.
Or like, my lord, the scalp bar, thin bars, from scalp bar to it become thin bar. Then it is different declared goods.
Different declared.
That was in the context of some other item. Now, following that judgment, the state again denied the refunds.
What is the judgment?
You know, the judgment has been referred to in the judgment of the Union Bench of this honorable court.
Okay. Okay. The state denied.
Denied.
Okay.
Now, some of the dealers, my lord, approached this honorable court.
Okay. States. Is there any reference there so that
No, I give the reference.
for my
I give the reference, my lord, a just
That judgment, Supreme Court,
my lord, that is
come to page 118,
you will also
59.
find
Is it that case?
1989, one SCC,
19,
89,
1989.
one SCC 724.
1989, 1 SCC 724.
Oh,
What is the name of the case? Any
that is,
idea?
my lord, state of Tamil Nadu versus Mahi traders.
State of Tamil Nadu. Mahi traders.
Mahi.
Traders.
Mahi.
When different it's under 1 and 3 are in process. Then would be city. Huh? City. 9. Okay, that judgment, it appears that that judgment says that if under 1 entry, there are sub entries
My lord,
and some process for say item like you have said in say iron,
my lord.
it undergoes some changes, then all these separate entries are to be treated as different declared goods.
My lord.
That is the concept.
Was there, my lord, there constitution bench judgment, which was, my lord, the reference is, I'll give you also, my lord, A. Haji Abdul Sukur. I'll give the citation, my lord. A. Haji Abdul. The reference has not been given, my lord, in the judgment. A. Haji Abdul Sukur. Constitution mention. Now, this denial was again challenged.
Okay.
Before this on the court,
This code.
my lord. Citation, my is not the.
Okay, denial was changed. What is the relevant paragraph in the repetition? Repetition.
Look at, I'm giving a judgment note at page 117.
This is just so that that is annexer.
Well, Annexure 13.
Annexer 13. What is the relevant paragraph?
My lord, I will take a look first.
Relevant paragraph 23. Okay. Paragraph 23. Annexer 13. Annexer 13 is at page
Yes, sir, 117, Lord, type copy.
117. Let us read 117.
My lord.
Yes.
My lord, also see at page 100.
That WBC is 6646.
My lord,
DB.
BB.
What is the party's name? Any idea?
My lord, that is party's name, you'll also find in the.
In paragraph 23.
Paragraph 23, my lord, and then the SLP's.
Paragraph. Let us see paragraph 23. Copy of the order.
That was, Guwahati Carbon Limited versus State of Assam.
Guwahati Carbon. Versus State of. Okay. Let us read that on this
Take a lordship to the last but one paragraph,
page.
117.
Yes.
There were two repetitions, my lord. So the application was rejected by the government of Assam. White order dated so and so, annexure 4 in WPC number 4586 of 2008 as follows. Common ground, my lord.
Hmm.
As indicated above, raw petroleum coke is commercially distinct and different commodity from calcined petroleum coke. Raw petroleum coke loses its original identity in the process of manufacture of calcined petroleum coke. It may be mentioned herein that under Central Excise Act, raw petroleum coke and calcined petroleum coke are treated differently and are being subjected to excise duty separately. The apex court in Bharat Coking Co Limited and Allied showing so, while dealing with the definition of coke and coke under the Quality Control Order 1945 framed under the Essential Commodities Act, observed that though the definition club coke and coke together, in fact, the two products are distinct and different. While coal is a stone-like product excavated from the earth, coke is a processed product of coal obtained from certain processes. Similar distinction exists between raw petroleum coke and calcined petroleum coke, in as much as after process of calcination, a product which has distinct commercial identity, that is calcined petroleum coke, emerges. A constitution bench of the apex court in the case of so-and-so held that the fact that certain articles are mentioned under the same heading in a statute does not mean that they constitute one commodity, merely because different goods and commodities are listed together under the same subheading in section 14 does not mean that they are to be regarded as one and the same item. Listing of the two or more products under the same category under Central Sales Tax Act cannot and does not mean that the products are identical and that they are one and the same product. A category means a cases in individual items which may differ from each other in various ways. Now, this citation of this A. Haji Abdul
Yes.
Supur is AIR 1964.
AIR.
1964.
Hmm.
SC 1729.
Yes.
In the instant case also, although RPC and CPC are listed under the one heading under Central Act, it may be noted that calcined petroleum coke is a product which emerges after raw petroleum coke is subjected to the individual process of calcination. If the product CPC has undergone an irreversible chemical change in the industrial process, it is chemically and physically a different item from RPC. In fact, CPC manufacturing industry units based in the state claim different industrial activities, incentives, including transport subsidy by virtue of the fact that CPC is a finished product after industrial chemical process being used as a raw material. So on this ground, the refund was rejected.
Okay.
Now this honorable court, my lord,
On the basis of universal hydrocarbon.
my lord,
DP. Yes, universal hydrocarbon.
held that
Totally unable to accept. Okay. Right, Conservative Services, the view taken above is directly in conflict with the line once the entry. What is Reported held. This. This citation is AIR 1972 SC 164 is AIR, sorry, 1971 3 SCC perhaps.
Right.
Okay. 1971 3 12. That petroleum fee is one from governed by the expression code within section 14A. A relevant extract of the judgment. Okay. And for the view that coal includes coal in all its forms must be taken. In other words, however, which had been derived extract from coal by the religion fully supports the rest.
Mainly this on the court came to conclusion, Lord, that when the same entry has been interpreted,
So what is the division bench view?
so the division bench here, Lord, requires 122 year also, see.
Treated to be part of one entry coke in all its forms. The principle that different commodities affect separately is distinguished. Judgment of the Supreme Court in respect of same query is not necessarily going to so and so, where different commodities will affect separately later on. So, the judgment of which was held to be distinguished in its applicability. So it goes by hydrocarbon,
Hydrocarbon.
universal hydrocarbon.
That when said Lord, when the specific entry has been interpreted by the apex court,
Ah.
then a general observation which has been made, that will not be applicable.
Or general principle will not. Okay. Okay. H. Basis of difference. So this was dated judgment.
This is judgment dated. I mean, dated.
Any date? Date?
By 12.
The copy. is there.
12. In the no.
Copy you also find.
Huh?
That's when the copy.
123.
123.
Page 123.
Case status, case disposed, decision on 12 of December 2000.
12th of December.
12 December 2012, no?
Yes.
Very lucky date.
Date of judgment. 12th of December.
2012.
Can you resume after?
Well,
2 minutes? Oh, yeah.
I mean, again, this judgment of the division bench, SLP was preferred
SLP preferred again. By states.
by the state.
SLP. Preferred. Against WPC 6646.
You have two judgment by common order, Miller. 6646
And
4586 of 2008.
4586.
4586 of 2008.
2018. One was 2010.
By law. Both were disposed of by the common order.
WPC 4586 2018.
8.
2008.
8.
Okay, 8. Yes.
129, Miller.
Common chat. Page 129.
My lord,
Yes.
the
page
interim order
129.
was passed by the apex court.
Mhm. Civil appeal.
No, this was dismissed, Lord.
Ah,
SAP was dismissed, also can see.
55185519 2013. State of Assam. The carbon date
129,
date
January 12, 2017.
12 January 2017.
17,
Dismissed.
my lord.
Dismissed. Okay. Universal hydrocarbon
My lord. Following this item.
based on division means dismissed because general principle will not apply because already it has been interpreted in universal hydrocarbon, raw petroleum coke and calcined petroleum coke are one and the same. So general principle will not apply. Division means dismissed. SLP preferred, that was dismissed.
That was dismissed also following the same judgment.
Same universal hydrocarbon.
Now, by the interim order, my lord, the apex court directed
We are informed that pursuant to an interim order dated an amount of interim order by Supreme Court,
Supreme Court.
an amount of rupees so and so is lying in fixed deposit account. Your dismissal of the first assessment would be at liberty to withdraw the so and so which accrued interest on making an appropriate application. Yes,
Now, what happened?
that was directed to be deposited in the Supreme Court registry.
Which was kept in a fixed deposit, and 50% was to be kept in a separate account by the state government.
50%.
50% of the total refund was to be deposited in the registry of the Supreme Court, and 50% was to be kept in a separate account.
So interim order was about deposit of 50%.
50% deposit and 50% to be kept in a separate account.
Deposit of 50% in Supreme Court registry.
I know.
And other 50%?
In separate account with the state government.
Oh, by the state government.
I know.
Other 50% to be kept in account by state government. Okay. So that 50% deposit in a Supreme Court registry, if appropriate application is filed, accrued interest plus 50% deposit will be refunded. Yes.
So the balance 50% was also refunded by the state government.
If any further amounts are due under the order of the High Court to the first assessment, the first assessment would be at liberty to take appropriate steps for recovery of the same.
That was not also refunded
Refunded by the state.
by the state.
That is okay.
Total was about 5 crore.
Okay.
So 2 crore 52 in the registry and 2 crore 52 lakhs something was by the state government.
Okay.
Similar order was passed by this honorable court. Some writ petitions were filed in Guwahati at this honorable court. And this honorable court also passed the same interim order. And thereafter passed the final order, which you'll also find at page 131.
131.
By the way. Earlier, the interim order was passed, same interim order, and thereafter, after dismissal of the SLP,
Congratulations. Filing before interim orders passed
and thereafter, my lord, the
Final
final
order.
order passed,
Interim order to deposit.
deposit 50% in the registry of the High Court to be kept in the fixed deposit and 50% in the separate account. In respect to some other dealer.
Let us read page 131.
My lord.
Let us read the operative part of 131.
131, you'll also find. At page 134. In view of the determination made by the Supreme Court, it is not disputed that the appellant would be now be entitled to recover the aforementioned amount as well. As such, the applicant is granted liberty to approach the Commissioner of Taxes Assam by making so and so. Prior to that, my lord, the registry. Prior to that one paragraph, my lord.
Paragraph.
Paragraph page 133. The last but one paragraph.
Hmm.
In view of the above, the interlocutory application is disposed of by permitting the applicant to approach the registry of the High Court, seeking withdrawal of the amount as stated above, going without with the account accrued interest. If such a prayer is made by the applicant, the registry so and so with the verification and so and so to release it.
Yes. Till now, whether you were party in any of the litigation,
Myself,
this Digboi Carbon
No.
Private Limited,
no. I was not party. But no communication was received from me to me for rejection of my refund applications. The rejection of refund applications only in respect to two SSCs who approached this on court.
okay. Refund application in respect of yours was not
What pending?
decided, pending.
Pending. Now, from the assessment year 2009-10,
Hmm.
I filed my refund applications on different dates, which I have given below from annexure 1 on annexure. Yeah, bro. From 56 page minute onwards,
56.
my lord.
Page 56 to
56 to 75.
75. Refund applications for the years
It will be not up to 84.
84.
My lord.
Refund applications
For
For
the
the-
assessment year 2006-7.
year 2006-7.
to assessment year earlier I have given this mail order. The applications for up to page number 84,
Hmm.
then up to 2011-12.
2011-12.
Well,
And period of filing application
that is different dates.
starting from, say,
Well, starting below 2006-7
no, that is assessment year.
assessment year.
Date of filing application
Well, I'll just give you. 6-7 was 26/4/2010.
26/4/2010. Last of
Well,
that.
I'm going to look a chart I will prepare. And I will take maybe for also the date of the submission of the application along with the extra numbers.
1 minute. Assam cell 86, 92, 95, 89. And this issue also started in 2010.
I know.
8, 9, 2008, 2009, 2010.
Thereafter subsequent level of other periods also.
No, this Guwahati Carbon
I know.
WBC or 4586. Who was the petitioner there? 4586.
451 was below Guwahati Carbon, another was Brahmaputra Carbon.
Huh?
Brahmaputra Carbon. Another was Brahmaputra Carbon.
Brahmaputra. So 2008 Brahmaputra Carbon writ petition,
My lord. And 2010.
Guwahati Carbon writ petition 2010. So in and around the same time you have filed the application for remand,
Applications regularly were filed.
refund.
Refund.
Not just I wanted to examine whether you are a fan-sitter or not.
No, man. That is one of the ground work again.
Huh?
In
No,
the-
that is the suddenly it came to my mind.
know.
So whether you should be, that might be a ground. So
That is like filed in 2022, all applications.
then
Then something, the ground may be there.
yes.
But although.
So, Mr. Counsel, please give a date of your application,
I-
refund application.
I will give date, period, annexure number.
Yes,
And all this.
yes, yes.
Now, my lord, for the other periods also, I find the applications in time, I will give a chart. Now,
So what is the treatment given to your refund
I
application?
should proceed the applications for 2009-10 to 2011-12 were not available on records of the department. I was directed to file
2000?
9, 10, 10, 11 and 11, 12.
2009, 10, 2000,
10, 11
10, 11,
and 11, 12.
2011, 12. Your applications,
My lord.
petitioners, refund application. Applications for the years. To be not in the Did they speak specifically?
No, my lord, that we submitted a letter.
Ah.
We were told verbally on page 100,
100?
my lord. In 2015, we resubmitted the applications.
Uh, which page?
Page 100.
100. Hundred. Okay. Hundred. 102, 100,
100 and after 101,
101.
we submitted for 12, 13, 13, 14 and 14, 15.
So resubmission or application?
Resubmission was for 2009, 10, 10, 11 and 11, 12.
And 101 is for other years.
Other years.
This was submitted prior to any specific oral.
No, this was oral request by the assessment officer in 2015 we submitted. Prior to the judgment of the Supreme Court.
Yes.
No, my lord. After the judgment of the apex court, I submitted letter, my lord, which will also find at page 150,
150.
my lord.
Yes.
That in view of the judgment of the apex court, the refund may be granted. The period 2006-7 to 2015-16.
Yes.
Now thereafter, my lord, the assessing authority,
Hmm.
at page 154,
150. Yes.
passed different orders
On refund application.
refund applications.
Okay.
Now, this was passed under section.
For separate years separately or what?
Separately.
Separate years separate.
Separate.
Okay.
Now, you also can see page 155, one of the case I'm taking,
155.
five, paragraph 3.
Yes.
Completion of the audit assessment. You'll also got in. The audit assessment of the dealer for the 2006-7 was done by the Deputy Commissioner of Taxes on 10/3/2012. The assessment order is however silent on the reimbursement under section 15B of the Central Sales Tax Act 1956. The filing of the recuperation against rejection of the refund by the government in the meantime. Government of Assam by letter number so and so rejected the refund proposal of Guwahati Carbon Limited for the year so and so under the GST Act, giving detailed reasons thereof. On the basis of such communication of the government, the Commission of Taxes Assam by letter dated so and so rejected the refund proposal of the Brahmaputra Carbon for the year 2004-5. Being agreed, the dealer approached the Honorable Guwahati High Court by way of filing retractation so and so. Verdict of the High Court in favor of the dealer. The Honorable Guwahati High Court allowed the petition, ordering that the Honorable Supreme Court in the case of State of Bihar, so and so has already held the RPC and so are same, and hence the controversy may not be entered into. Filing of the SLP, thereafter the Supreme Court judgment, then you also may again skip over. And may come to Lord. Page 157. The ground of refund.
157.
By law. But the same ground has been mentioned about section 15B. And thereby the amount refundable was determined.
The taxpayer claim as refund by the dealer as of section 12. Such goods. Subsequent solid dealer purchased from revenue by paying back. Sold the same after converting the same is the same dealer. High Court for State of was upholding the counts of the judgment of the fact. Police support. Police support the dealer. 157.
By law.
In view of so and so, I proceed to reassess. In this table,
The last part, no, amount refundable.
amount refund. Okay.
In this, where the different orders are passed, and I'll give a chart of lordship, you know. Your lordship for different assessment years, page number, and the date of the order. Section 42 building.
Yes.
This order was passed under section 42 of the Assam VAT Act. You'll also find at page 154.
Assessment. Assessment order. Passed. Under section
42.
42.
By law.
42 Assam.
VAT Act.
VAT. What is
You'll also make LEC section 42.
act? A
And the
Value Tax Act. What's the name of? VAT Tax 9.
will prepare comparison of the relevant provisions, you know, for conveyance of lordship.
42. Power of the yes.
Says, my lord, where any court or tribunal passes an order in appeal or revision to the effect that any tax assessed under this act or the Central Sales Tax Act should have been assessed under the provisions of the law other than that under which it was assessed, then in consequence of such order or to give effect to any finding or direction contained in such order, any turnover or part thereof may be assessed or reassessed as the case may be to tax any time within 5 years from the date of the order, notwithstanding any limitation period which should arise applicable soon.
Yes.
But with due respect, this section 42 may not be squarely applicable in the present case. But the order was passed to give effect to the judgment of the apex court on the refund applications. When I come to my submissions before also, I will make the submissions. That assessment is altogether a different thing. And determination of the refund is altogether different. Determination of the
Okay.
refund can only be after completion of the assessment.
Okay, this should be your submission.
My lord.
We'll keep aside
Well,
submission.
I will come to it.
Let me have the chronology of events.
That's why I'm pointing out clearly that section 42 may not be
Okay,
squarely applicable in the case of the petitioner. In the case of the law,
so where are these are the assessment orders.
my lord.
So you'll provide a table.
Provide chart, my lord.
Okay, this runs up to which page?
Is 197.
197.
194.
It runs from,
I'm just, madam, 193.
okay, 193. So 154 to
193.
193 are assessment orders.
Orders.
So issue and observation are same. These are assessment orders.
Whereby the refund was determined.
Refund was determined. So question of 42.
May not be squarely applicable, but in these orders,
That was not dealt with.
Well-
Dealt with. In this order, section 42 was regarding limitation was dealt with.
no, nothing limitation is not applicable because that was says that the irrespective of the limitation and all those things, those issues are not there.
Okay, last of the 193.
My-
Okay. Yes,
Thereafter, at page 194,
194. 81. Yeah,
I received a letter from the Joint Commission of Taxes
29, 2009. Okay, this has reference to your claim reimbursement paid on RTC for assessment year to under 15B pursuant to government, and also with regard to your claim for payment of simple interest on such reimbursable that amount from so pursuant to interim order of not. We have asked to furnish an undertaking by way of an affidavit to the effect that you will have to move further claim for interest other than 10% claim by you from so to the order in order to. Yes.
So up to this stage, there was no dispute of the refund.
Okay.
They only wanted an undertaking that you will not claim interest other than the period for which it is specified in the letter. So I furnished the undertaking, which will also find page 195. And undertaking at page 196.
195 and 193 undertaking on 21/9 next day.
Well. on,
Okay, these are the affidavit,
my lord,
197. 197.
page 198. Your lordship, may I see?
Hmm.
Commission of Taxes forwarded the refund applications to the government for approval.
Approval. So far, just this some figure is mentioned here.
Well,
There is no dispute about the
no,
figure.
No,
That is
there is no
not
dispute.
to be gone into.
No,
Okay. Shh. Next, 21. Page 198. 25/10/2019, Commissioner seeking sanction.
for approval, it was forwarded to the
Uh,
government.
Seeking approval for sanctioning refund. Okay.
Lordship, second paragraph.
Hmm.
The refund proposal is processed in this commissionerate with the views taken from the legal administrator Assam, while letter number so and so, and the direction of the government, Your Lordship, kindly.
Hmm.
And the direction of the government so and so dated 14th August 2019.
Hmm.
Wherein it has been directed to process the refund proposals of so and so similarly as so and so limited. Those lead petitioners. So,
Brahmaputra and Guwahati.
my lord.
Hmm.
So the direction was there, who was taken, legal administrator who was taken, and the government direction was there to process the claims. The second one, third paragraph. no? While processing the refund proposals of in the apex office, it has been noted that the dealer has submitted the entire refund proposals before the concerned commissioner, assistant commissioner of taxes in time to time. But
That is not denied.
Hello.
So that fancy the concept would not come.
not come. But due to pendency of the legal proceedings from the Honorable Supreme Court of India in similar position, so and so, number in respect of the genuineness of the refund disbursement 15 law, all proposals of refund of the dealer were kept pending before the Assistant Commissioner of Taxes.
Yes.
Now, the next paragraph says, my lord, that the petitioner was not involved in any legal issue before any competent court.
Fourth paragraph. In view of the judgment, let us see.
No, in view of the judgment of the order of the Honorable Supreme Court in the matter of so and so, subsidiary numbered as so and so, the common identical question of law has been settled in the strength of the judgment and order so and so. The refund reimbursement amount has been already been sanctioned to the dealers who were involved in the legal issue. It is pertinent to mention herein that the dealer, promoter was not involved in the legal issue as mentioned above before any competent court.
Yes.
Now, next page below. As per the judgment and order of the Honorable Supreme Court, and as per the views of the LR Assam,
Hmm.
there is no dispute with regard to the tax amount refundable, reimbursable to Messrs. Digboi Carbon Limited, that is petitioner, under section 15B of the Central Sales Tax Act. But a question arises regards the applicability of the interest to the dealer on the reimbursable amount of tax. So far as the refund and reimbursement,
Hmm.
it was held that with the view of the LR Assam, there is no dispute with regard to the amount of refund or reimbursement, only the amount about interest. Now, to clarify the issue in respect of applicability of interest, refundable amount, the commissioner has taken a view from the LR, where the LR Assam has opined that the dealers have been entitled to 9% interest for the period commencing from 90 days from the application claiming refund till the date with the refund is granted. But in the similar conclusion, refund proposals of so-and-so and so-and-so, the LR suggested that if the department allowed 10% interest with effect from 12/7/2013 for the periods not included in the court cases, then the amount will be obviously less than the amount calculated with 9% interest from the expiry of 3 months from the date of dealer. As directed by the LR Assam, the government has allowed 10% interest with effect on so-and-so to Brahmaputra Carbon, Guwahati Carbon for the period so-and-so, with undertaking that the dealer mentioning no further claim of interest and the rest periods with 9% so-and-so, so-and-so. The same principle is also taken in this matter as by the government, while letter dated so-and-so of 2019.
The same?
Principle about
Ah.
interest. The same principle is also taken in this matter as asked by the government, while letter number so-and-so dated so-and-so.
Hmm.
So the government also asked only about interest. So far the refund is concerned, nobody has disputed,
Hmm.
including LR and the government. They only wanted that the interest should be in that manner. For that, the undertaking was taken.
The undertaking was taken for what, how much? 10%?
10% from a particular date. LR said that it should be from the date, 30 days, 3 months from the date, expiry of the claim petition, and that will be more. So is view of the Supreme Court judgment, that direction may follow.
Much more?
Normal cost, it will be much more. Because it will be 90 days, expiry of 90 days from the date of submission of the claim.
You submit it on 1st of January,
2011.
say,
So
then 90 days, March 30, up to March. From,
March no interest.
from April 1st onward, law sets in and interest is payable. LR says. Now, the question of rate.
Rate was 9%.
Rate was statutorily fixed at 9%?
9%.
Statutorily. Under what section?
There is section 52 will adjust it. But the Supreme Court in the order,
So I remember some 10%, somewhere 10%.
10%. So they said 10% from the date of the judgment. So that will become less. So in that case, it was so. So here also you take the undertaking. And the dealer also wanted the money. So
Okay, let us read once again page 109 for clarify the issue in respect. Once more.
My lord, to clarify the issue in respect of applicability of interest on refundable to reimbursable amount, this commissioner has taken the view from the LR Assam, wherein LR Assam has opined that the dealers have been entitled to 9% interest for the period commencing after 90 days of the application, claiming refund till the date when the refund is granted.
Okay, this is traceable to which provision?
Section 52.
Section
52.
52.
My lord.
Just, I'll have it.
435. 6 interest.
Mr. Borua and Mr. Dotto, you please give the provisions also along with that table.
Separately, we'll give all the provisions.
Just so that
It becomes
easily Instead of opening the book,
No, no,
it can
no.
be
We'll give a comparison of all the relevant provisions.
52,
One, at the bottom at page 435.
52. One. Two. Assam. Wet. Act 2003. Interest.
My lord.
It deals with interest.
My
Okay, interest. Let us see.
bottom below.
I registered dealer entitled to refund in pursuance of any order under this act, including assessment in pursuance of any order. The court shall be entitled to receive in addition to a reverse simple interest. Okay, 9%.
9%.
Okay,
And that will be
9%.
per annum for the period commencing after 90 days of
Okay.
the application.
90 days. Till refund.
Refund.
Let us go back to 199 again.
My lord.
Okay, 9% per annum for a period commencing after 90 days of the application claiming refund till date of which
But
granted.
in
But
occasions,
we start with but.
but in similar occasions, refund proposals of so and so are suggested, the Adar Assam suggested that the department allowed with 10% interest with effect from 12/7/2013. That was the date of the dismissal of the SLP.
Okay, this SLB dismissal.
For the period not included in the court case, then amount will be obviously less than the actual amount calculated with 9% interest from the date of expiry of 3 months from the raising of the claim by the dealer.
What is he says?
My lord, we say that if 9% is calculated as per the provisions there, interest will be much more.
Ah,
But if we take that whatever Supreme Court said in those two cases, 10%, and we give in that way, the interest from the date of judgment, interest will be less.
but so far, a refund is concerned, if section 52 takes into account, then it is statutorily
Yes.
prescribed that after a refund
Fine,
application is filed and after assessment it is found that yes, refund is to be granted, then it sets in the statutory provision sets in after 90 days that 9%.
That's
So these two entities were in litigation because of their refusal of. So
they are bound by the Supreme Court order. They were bound by the Supreme Court order, the 10% from the date of the judgment.
okay, where is that? The
No, that
10%
was
of the date
judgment.
of judgment.
No, 10% is interim notice.
Just to have a look.
Yeah, the reverse report, the India Supreme Court interim order.
Dismissal. Maybe page 129.
But that was an interim order, my lord.
Or our division bench order.
No, in division bench order is not there, my lord. This was in the Supreme Court's order. Where the interim order was passed for 50% keeping separately and 50%. My lord, I've reproduced. But there is. There is 24.
24. Yes.
Also you find that conditions.
Okay, so that interim order,
My lord.
12/7/2013.
My lord. I provide a copy of the order also. my lord.
Mhm.
Little.
Interim order dated 12/7/2013. 50%. 50%, but it was silent about, okay,
My
10%.
next
10%. Okay, that
The next one, in the event. the
50% in the registry,
Ah.
50% deposited in the registry of Supreme Court, that will accrue normal interest.
But you said, my lord, that if you withdraw it, that amount, it says, my lord, if by guarantee. bank guarantee.
See, Roman 1,
My lord,
50% of the refund amount pursuant to the impugn order shall be kept separately in a separate account by the appellants.
My lord.
And
I may
next,
just read my lord.
remaining
50% of the refund amount shall be deposited by the appellant with the registry of this court within 2 months from today. Thereafter, my lord, the amount so deposited may be withdrawn by the respondents on furnishing suitable bank guarantee with the satisfaction of registered so and also undertaking that in the event the appeals being allowed, the amounts of withdrawn shall be restituted to the appellant along with 10% interest from the date of the withdrawal.
So it was on you actually.
My lord, that's third one.
It was on the
Petitioner.
that carbon,
My lord.
carbon,
No,
Guwahati carbon.
Fourth one, my lord, third one.
Ah,
In the event the appeal being dismissed,
okay.
the appellant shall pay to the respondent 50% of the amount which has been kept in a separate account along with 10% simple interest from today.
From today. Okay.
So that was
In Guwahati carbon and Brahmaputra carbon.
not a general application.
Brahmaputra carbon.
That was in view of the interim order passed by the apex court.
Okay. Come to 199 again.
But
199.
they said that if this same thing is applied,
Okay. Okay, let us see.
my lord,
But in similar occasions, Assam has suggested that if the department allowed 10% interest from so and so for the periods, not okay. 1 minute.
the amount will be
1 minute.
obviously
1
less.
minute. 1 minute. Paragraph 24.
My lord,
For a period not included in the court case, amount will obviously be less than the actual minimum if calculated with 9%. Okay, they try to save the money to conveniently forget the provision of section 52.
and in that process, they took an undertaking
Okay, from those Guwahati.
from us also. That's why the affidavit which he filed earlier.
Okay. You now this undertaking will, one thing is refund,
Hello.
and second part is
Interest.
interest.
On the
So
interest,
far as refund,
no dispute.
no dispute. Now the question of interest. Because of that interim order, which was Guwahati Carbon and Brahmaputra Carbon.
Hello.
So LR has made an opinion that from 12/7/2023 to the date of refund, you give 10%.
If you give it, then.
You give it 10% interest and forget about 52. Section 52.
And they knew it, my lord, that statutory is not possible. So they took an undertaking from us that you will not claim any further beyond this one.
Okay, what is your undertaking?
Your Lordship,
Just revisit once.
para, page 197, para 4.
190. No, your undertaking, one copy was there, affidavit.
This is 196, it starts.
Huh? Oh, okay.
And 197, para 4.
197, para
4.
4. Oh. Okay.
But I was directed,
We'll
that
have
you-
no further claim.
I was directed that you give this undertaking.
Issues. Undertaking. At 197. Para 4. 10% simple interest. From 12/7/2023.
That is the 13, that is the date of the interim order that was.
Guwahati Carbon and Bahota Carbon. So you have been made bound.
found. But according to me, Milord, even now.
Okay, well,
No,
legal issue.
I am saying, Milord, that such undertaking, which is contrary to the statute, has no meaning.
Okay, well, that may be an issue.
I'm not coming to that.
Huh.
I'm not on disputing the issue.
Let us read further then after this, but then as directed
My lord,
by the LR, Assam 199.
my lord.
The government had allowed 10% interest with effect from so and so to Brahmaputra Carbon and Guwahati Carbon for the period to so and so with an undertaking from the dealer mentioning no further claim of interest and rest period with 9% simple interest under section 52. Okay.
So
The
for
same principle is also taken in this matter
Yeah,
as
so
asked by the government.
Now kindly mark it, Milord. What it says. And rest periods. With 9% simple interest under section 52 of the act.
Okay, race periods.
Only the periods which were involved in the court cases.
Undertaking, okay, race period 9%. So meaning thereby, the period prior to 12/7/2013 and
10%?
after expiry of 90 days from the refund application, this should be 9%. Is it correct?
The refund which was granted as per the direction of the honorable court, 10%. And the subsequent periods, 9% as per 52.
Subsequent.
My lord.
Okay.
Subsequent means after 12/13, so the order was 12/13, 13. You'll also see the period, you'll also see the period, 5/6 to 12/13. So 5/6 to 12/13, 10%.
Okay.
From
I
the
have
date of judgment.
okay.
And
I have to rise
My lord.
to at least the factual and sequential events, then law points maybe at later date. Sorry for the delay, some works.
6 January.
I had to go. We are at
199.
199. Yes.
Now I am going to below the middle after the bold portion.
That bold part, the same principle.
My lord, is also taking service. In this context, it would be appropriate to give a brief outline of the event facts leading to this refund reimbursement proposal along with the interest thereon. So first is only about company. The dealer makes local purchase of the raw petroleum coke from refineries in Assam and sells the finished product petroleum petroleum coke in course of interstate trading commerce. Filing of return and so on. the dealer filed its annual return in form so and so, along with the CS audit report claiming reimbursement of the refund section 15B of Central Sales Tax Act of a sum of rupees so and so, dated so and so for the assessment 2006-7 on account of VAT paid for the raw material petroleum coke, which is declared goods on the ground that the CST were paid on interstate sale of special petroleum coke, which is in the same item, citing the judgment of the Honorable Guwahati High Court in so and so. It is pertinent to mention that Section 15B of the Central Sales Tax Act provides for reimbursement of the local taxes paid on the interstate sale of declared goods subject to condition that CST is paid on the interstate sale of such goods. The completion of the CST, the audit assessment of the dealer for the period 2006-7 was done by the Deputy Commissioner of Tax of Tinsukia on so and so. As per the assessment order, the amount reimbursable under Section 15B of the Central Tax Act for 6-7 was rupees so and so, and assessing authority has allowed interest to be 10% per annum, amounting to rupees so and so from 12/7/2013 to 12/6/2018, and on the total amount refundable as per the assessment order amounts to so and so. Forwarding of the refund proposal by the ACT. The Assistant Commissioner of Taxes Tinsukia unit being satisfied with the refund application forwarded same to the Deputy Commissioner of Taxes Tinsukia, and the Deputy Commissioner of Taxes have been satisfied with the refund proposal forwarded the concerned ACT has provided the same to the Apex office. Obtaining of opinion of the legal members on interest or claim for the smaller occasions. On the claim petition of the interest on VAT amount reimbursable Section 15B of the Act so and so, the views of the LR was sought through government by order dated so and so. The learned LR Assam has furnished views dated so and so, which had been communicated by the government letter dated so and so. It is necessary to extract below the 11% of the LR's opinion. It is noticed that Section 52 of the Assam Value Tax Act says that registered dealer entitled to refund in pursuance to the order or assessment under this act shall be entitled to 9% interest per annum for the period commencing after 90 days of the application, claiming refund till the date on which the refund is granted. Thus, this is a statutory interest. It is observed that the refund application, refund payable in Section 15B of the CST Act entails claims of statutory interest under Section 52 of the Assam VAT Act. Generally, the rate of interest and the rate of entitlement in respect of the present similar claims shall be according with the provisions of the Assam VAT Act. Therefore, it may not be correct to hold that the interim order of the Honorable Supreme Court dated so and so will regulate the rate of interest of the date of settlement interest in all cases. Present orders of the Honorable Court is applicable in respect of the claim for the 2004-5 only. Therefore, rate of interest and rate of entitlement in respect of the subsequent assessment years are to be determined in accordance with Section 52 of the Assam VAT Act and not by the interim order. However, finding of the Honorable Court insofar as the refund to claim period of RPC and CPC being declared goods is equally applicable for the present and all similar claims. As refunds for the assessment of so and so have already been allowed with 10% interest with effect from so and so, amount refunded are obviously less than the actual amounts. If calculated with 9% interest from the expiry of 3 months on the aging of the claim respective years as per Section 52. This may, however, be recalculated by department and if found to be so, paid amount is less. It may be better not to reopen the same in absence of any claim by the company. For the region's proposal, for the refund proposal for the assessment so and so, with 10% interest from so and so, the department may, due to the same regions, allow and sanction the proposal subject to consent of the undertaking from the claimant for the further claims. Filing of petition against rejection of the similar refundable. We may skip over. This is about the High Court order, filing of the SLP. The SLP is, it is there. Then, my lord, para 7 may come. Assessment pursuant to the Honorable Supreme Court's order. In the wake of the Honorable Supreme Court's order, The assessment was completed by the Jurisdiction Assistant Commission of Taxes unit on so-and-so, allowing the claim of the dealer reimbursement of local tax paid in the terms of the provision section 15B of the so-and-so act. The assessment orders which I placed before us. However, in the event it is found that the payment of interest at the rate of 9% as per section VAT Act will be less than the amount actually paid, proposed to be paid, suitable adjustment or corrections may be made in the light of the discussion above, barring the assessment year 2004-5. Hence, simple interest at the rate of 10% may be allowed to the dealer from so-and-so as per the interim order of the Honorable High Supreme Court for the assessment 2004-5, subject to furnishing of the concern resulting to the effect that the dealer will not have any further claim of the so-and-so. Section 50 of the Assam VAT Act, read with Section 29 of the Act, read with the provisions of so-and-so, provides for refund of the amount paid in excess. As the amount to be refunded exceeds rupees 50 lakhs, prior approval of the government is necessary as per the provision section 29(1)(e) of the Assam VAT rules. Accordingly, the proposal is forwarded to the government for according its approval for sanctioning sum of rupees so-and-so for the assessment of so-and-so on account of the tax paid on the purchase of raw petroleum coke in terms of section 15B of Central Sales Tax Act in compliance with the order of the Apex Court and view of the LR. And the taking duty signed by the concerned officer and the underside are enclosed therein for necessary order. The proposed amount proposed for sanction is debitable so-and-so.
This was on which date?
But this was on 25/10/2019. For the assessment year 2006-7. Similar
Okay.
proposal for 2007-8, you'll also find it 2203. Same date. Earlier was 6-7, this is 7-8.
And it's 51. 498.
For 8-9, you'll also find it page 208.
1 minute.
By the way. I'll give a chart of this one also. Page 9 at page 208.
207, 2032, 207.
2006-7-8.
Oh.
For 2008-9, page 208 to 212.
2007 and 8. 2008 and 9.
208 to 212. In the list of dates it is given below.
And
2009-10. From 2013 to 2017.
yes.
2010-11. From 2018 to 2022.
Yes.
2011-12. 223. 223 to 227.
2011, 12.
11-12.
11, 12. Up to
2,227.
27. Yes.
For 2012-13.
Yes.
228. 232.
232.
2013-14. From 233.
1 minute. 2000.
13-14.
13, 14. 233 to?
237.
Hmm.
For the subsequent 2 periods, the applications are pending.
Okay, what is the date?
But the
Same date?
No, applications were submitted, no orders have been passed.
No, no, no. Date of the order is same. 25/10.
Well,
Date of, no, this annex, all this assessment year from 2006 to 2007
The proposals
up
were
to
submitted.
2013 to 2014,
My lord.
order is, sorry, the date is same.
Date is the same
No.
and the.
Huh?
Date
25 October?
It is 23rd December 2019 for 13 and 14. Page 233.
Huh? 13 and 14?
13 and 14 is 23, 12,
Yes, my lord,
19.
sorry.
Okay, 1 minute. First 6 is 25/10,
Yes.
2019. And last 2 is,
Last one, my lord, 23, 12.
content is same?
Same, same.
Yes, yes, content is same.
And for 2 assessments,
37. 237. And what about the other
the
years?
2 assessment years, my lord. The applications are pending,
That is 2000,
14, 15, 15, 16, 16, 17 and 17, 18.
1 minute, 2014, 15, 2015, 2016, 2016, 2017, 2017, 2018.
2017, 18,
4 years.
4 years. The claims have not been processed. So the prayer also is for mandamus for direction to process the claim and to refund them.
Okay, these letters are from 198. By Commissioner of Tax. So this was the proposal.
Proposals after all scrutiny and etc. And it was recommended for below sanction. Now, after the said proposals were provided to the government, they remain pending. Sanction order was not passed. And in the meantime, at page 238,
Yes.
the new incumbent Commissioner of Taxes, my lord, he passed a fresh order,
Press order.
my lord. At page 238, that is 22nd September 2022.
Yes.
Now, as you also be seen in the first order
No.
by the Commissioner, my lord,
Proposal.
proposal, the refund applications were produced, and after being satisfied with that, the matter was forwarded to the government for sanction. Now, again, the Commissioner of Taxes, what he is doing, your OCBC,
This is the impugned one.
my lord.
This is the impugned.
Impugned. Page 238. The refund proposals of so-and-so for the so-and-so have been produced in detail along with the case records and findings are agenda. Now, he says that again, the the applications have been produced. One, we may skip over because this is only the VAT reimbursement scheme. 2, finality of the audit assessment made by the Journal Deputy Commissioner of Taxes for the so-and-so and so-and-so. The dealer had claimed reimbursement of the tax paid on purchase of raw materials, raw petroleum coke in terms of provision section 15B of the Central Sales Tax Act, relating section 15(1) of the Assam VAT Act. The matter was referred to the Journal Deputy Commissioner of Taxes Tinsukia for completion of audit assessment, specifically mentioning about the audit refund reimbursement claimed by VAT paid on the purchase of RPC. The Journal Deputy Commissioner of Taxes framed the assessment under the Central Sales Tax Act for the period so on 10/3/2012. However, the assessment orders did not allow the claim of reimbursement of tax paid on purchase of raw materials, in spite of the fact that the cases were referred to the Journal Deputy Commissioner of Taxes for audit assessment, specifically mentioning about the refund reimbursement claim for VAT paid on the purchase of raw petroleum coke. So, my lord, the commissioner says that the Deputy Commissioner of Taxes completed the assessment under the CST, but he has not passed any order for refund in the Central Sales Tax order. You also can notice that he says the audit did not allow the claim of the reimbursement of tax paid on raw materials, in spite of the fact that the cases are referred so and so for audit assessment. Now, audit assessment, the commissioner is saying of the Central Sales Tax. So, according to commissioner, in the audit assessment of the Central Sales Tax Act, the refund was not allowed specifically by the Deputy Commissioner of Taxes. Now, it was missing. The dealer did not challenge the assessment orders made by the concerned Deputy Commissioner of Taxes and did not file any statutory appeal division for net allowing reimbursement of taxes paid on purchase of RCP. It means that the dealer has accepted the assessment orders. Therefore, the assessment orders passed by Journal CEC has attained finality after the expiry of the period of appeal of revision under so-and-so Act. The pendency or other proceeding cannot be a ground for non-challenging the assessment orders. I'm not making my submissions here, Lord, as your lordship said, but only will not clarify that the stand of the Commissioner of Taxes is that in the assessments which were made under the Central Sales Tax Act, the audit assessments, the Deputy Commissioner of Taxes has not allowed the claim of refund of the VAT, and thereby those assessments become final. And since the SSC had not challenged those assessment orders, the assessment attained finality.
Just again refreshing and in the papers to which we have traveled
My lord,
so far,
my lord.
whether there was any deputy commissioner's order.
Well, earlier order was there, Central Sales Tax. We are not concerned here with that. I'll come to that, my lord. Why we are not concerned? Because the Commissioner of Taxation, you'll also may kindly note it only. The Commissioner of Taxation is speaking of the CST. That while completing the audit assessment for the central sales tax, the assessing authority has not allowed the reimbursement or refund. And thereby that order become final. And since the petitioner has not challenged that orders, the question of refund is not there. You also may only note it, my lord, that as per section 15B, the refund is not of the central sales tax.
Of the VAT.
The refund is of the VAT
If interstate trade and commerce takes place.
tax paid.
If VAT is already paid,
VAT purchased and levied, not paid,
And-
levied.
levied, and if during the interstate trade, in the course of interstate trade and commerce,
CST paid.
CST is paid.
So the refund is of the VAT. The question of granting of the refund of VAT under the CST Act does not arise. Why?
CST is not refundable. It is
Which
the
what-
VAT which is refundable.
So how the assessing authority can grant the refund while making the assessment under the Central Sales Tax Act? My lord, only after completion of the Central Sales Tax assessments, the assessing authority come to know that yes, tax has been paid. After he comes to the finding the tax has been paid, then he will take up the refund under the Assam VAT Act. Can an assessing authority pass an order of refund of the VAT in the assessment of the central sales tax?
Who does the assessment in CST?
Authority is the same,
Authority is same. Okay.
but the central sales tax is an act of the central act. But the authority to implement it is the state authority.
So after this, suppose just for my understanding, coke, petroleum coke, raw petroleum coke, calcined petroleum coke, that those issues are settled. Those issues are settled.
My lord,
Then question is the 4-5 conditions.
all full-
Your case is that you purchase raw petroleum coke. Then after making changes, it becomes
consent-
calcined petroleum coke. Right. So the for purchasing raw petroleum coke, VAT is levied. After changing it to calcined petroleum coke, that is
Told
goes through
in the interstate trade and
State-
commerce,
trade and commerce. And for that purpose, you pay sales tax,
CST.
CST. So thereafter, first one has to examine whether due CST is paid or not. If it is paid, then we'll again come to VAT.
No, first he is to examine
Ah,
that whether VAT was paid or not. It will be only on completion of the VAT assessment. That on purchase of raw petroleum coke, he will find out that whether VAT was paid or not.
VAT is paid or not. And thereafter also may examine whether CST is paid
Was
or
paid
not.
or not.
Paid or not. If it both are paid, then
Then
he has to go back
to the
to
VAT
VAT
for refund.
for processing the refund.
Right.
This is the should be the natural
My lord,
consequence sequence.
my lord.
Okay. Now what he observes,
He observed, my lord, that when the central
dealer
sales
has
tax
claimed
assessment is completed,
reimbursement of tax paid on purchase of raw petroleum coke in terms of provision of so and so, rate with so and so. The matter was referred to journal. This man is again referred the matter
no, no,
because-
he's saying of earlier one.
because Commissioner of Tax had
Com-
in his 25 October 2019 had exhaustively considered the matter after opinion from the LR. Whether LR's opinion is correct or not on the interest aspect, that is one aspect. But he has gone to a different tangent. The matter was referred to the Zonal Deputy Commissioner of Taxes, Tinsukia, for completion of audit assessment, specifically mentioning about refund, reimbursement, claim for VAT paid on purchase of RCP. The Zonal Deputy Commissioner framed assessment order, assessment under Central Tax Act for the period.
He is
Also.
speaking for the prior to the 10/3/2012. 10/3/2012, the assessment was completed. He is saying that prior to that, the matter was referred to the Deputy Commissioner for completion of the assessment. And ultimately, he completed the assessment on 10/3/2012. And he says that in that assessment order, the refund was not ordered to be granted. And that order became final, and that was not challenged by the SSC, and that has attained finality. Attained finality what? The not granting of the refund. Now, two issues which we are arguing about, that he is speaking of the central sales tax assessment, which has no connection with the refund of the VAT. Secondly, he is looking into the history prior to 10/3/2012. All these aspects have already been examined by the Commissioner in 2019 order. Once all the aspects have been examined by the Commissioner of Taxes, on the one hand, he says that order became finality and you have not challenged it. 2019 order also became final. Who will challenge it? For him, it is not applicable. For the SSC, it is applicable. That order also attained finality, and there is no power of review under the Act.
Okay.
Now we will also further similar. For the next assessment year, he is dealing in paragraph 3. Same thing. We may come to 4 below. In the meantime, in some cases, in similar matter, namely so-and-so, the Honorable Supreme Court in the renumbered so-and-so dismissed the appeal filed by the Government of Assam against the order of so-and-so, holding that the appeals are squarely covered by the judgment of the court reported in state of Bihar versus so-and-so, that has been rightly relied by the Honorable Court. It may be borne in mind that Big Boy Carbon Limited was not a party in this case, that case. How can I be a party that my claim was not rejected? The earlier commissioner said that because of the litigation, the claims were kept pending.
Yes.
Now, let me see. Based on the Supreme Court order of the so-and-so, the Assistant Commissioner of Taxes took up the orders for reassessment under Section 42 of the Assam VAT Act and passed the reassessment order, allowing the refund application along with the interest accrued therein, the details that was so-and-so. After last minute, the refund proposals were forwarded to the Deputy Commissioner of Taxes Tinsukia by the Assistant Commissioner of Taxes Tinsukia. On being satisfied with the refund proposals, provided the same to the Commissioner of Taxes Assam. Now he is up to that. The Commissioner Subsequent Commissioner, new Commissioner, is dealing with it. Then it was forwarded to the Commissioner. But after that, what the commissioner did, he is not mentioning.
Yes.
Thereafter, you also see 11 provinces Assam VATEC and this means the PS bed that 42 has been quoted. I produced read before you know.
Hmm.
Last, from a bare reading of section 42, it would appear that it has a repeated application. Section 42 can be invoked to correct a situation if an assessment by mistake is made in the CST Act instead of the VAT Act.
Which one you're reading?
At page 240,
240 paragraph?
after the section has been quoted,
Okay. Yes, from a bare reading.
or section 42, it would appear that it has limited application. Section 42 can be invoked or correct a situation if an assessment is made by mistake is made under a CST Act instead of VAT Act, or vice versa, and court passes an order to that effect. It is difficult to comprehend that the reassessment of 42 can be done in all situations just to give effect to any order of the court. Moreover, the assessments for the period mentioned above have become time barred, and as such, assessments are null and void of an issue.
Yes.
So he says that the subsequent assessment which was passed under section 42, that is null and void of an issue. Now, it is such a principle that those persons who did not challenge the wrongful action in the cases and accused to do the same and walk up after long delay and so on so. This is, my lord, again the backbenches, my lord, whereas the earlier commissioner said that the applications were filed in time and were kept pending because of the pending litigations.
Hmm.
Needless to say, Dibboy Carbon Limited was not a party to the case before the apex court or the high court. That means, my lord, under 141, wherever judgment is there.
Paragraph 7, please. It is settled principle of law that those persons who did not challenge the wrongful action in the case accused in the same and woke up after a long delay only because of the reason that their counterparts were approached the court earlier in the time succeeded in the report, then such person cannot gain the benefit of judgment rendered in the case of similarly situated persons to be extended them. Okay, they would be treated as fence-sitters. Oh, that's why visualized lectures and delays.
But
And the acquiescence would be a valid ground to dismiss their claim. Needless to say that this Dibboy Carbon Purple Limited was not a party in the case before that.
But you're also seeing in the earlier order when I was reading that all the claim applications were filed in time and that were kept pending because of the pending litigations.
Okay, four concepts he has brought.
No,
He has tried to brought.
my lord, I will,
No, we are not on the point,
no, I will,
not on the legal submission.
no, my lord,
In the order, he reflects acquiescence, delay, latches, fence-sitters. And fifth, you are not a party in the earlier two Guwahati Carbon and Brahmaputra Carbon. So this is his ground. So
I in short, my lord, I will not argue today.
yes. But fact is that
Up to that.
fact is that there was no adverse order passed against you. As per the Commissioner of Taxes earlier 25th October 2019, applications were received.
Right.
And they were kept pending because of ongoing litigation
Right.
at various forums. These are the facts.
Now I will summarize my submission, not today only, just give one or two lines and thereafter on the next.
Let us read from the above discussion.
That is rejected, my lord. There is nothing in there.
No, just 4 lines. Let us read. Let us complete it.
My lord, 100%.
Why keep the venom and the snakes?
No, my lord, certainly, my lord, I'm sorry for that. From the discussion, I do have no hesitation to hold that the reassessment made in 2018 by the jurisdictional assessing authority in the purported exercise of power section 42 of the VAT Act are outside the jurisdiction, hence void and deprived of any legal effect. Further, as per the provision section 39 of the VAT Act, the assessment order after expiry of 5 years from the end of the assessment will become time barred.
Hmm.
So he says, first, no power was there and become time barred, so that has no effect at all. Secondly, the original assessment made by the jurisdiction deputy commissioner of taxes, Supreme Taxes, did not allow the claim of the dealer for reimbursement of the VAT on section 15 of SAP, and dealer did not challenge such assessment order passed in 2012 for the assessment is so-and-so and passed in 2015 for the, and such assessment orders passed way back has attained finality on the expiry of the period of appeal or revision. Third is saying the Digboy Carbon Limited was never party in so-and-so before the dealer acted like a fence sitter and dealer did nothing to keep his claim alive by approaching any institute of reform. They never challenged the non-allowance of defense claim in the original assessment order made by the city John and so-and-so, and thereafter the claim continued.
What kind of order deputy commissioner has passed? Whether it was served to you at any point of time?
CST Act, I told before lawsuit, that was under the Central Sales Tax Act, assessment order was passed.
Is it part of a record otherwise?
I placed before lawsuit. No problem for that.
Okay. So this is the, what is the prayer here now?
Prior to setting aside this order of commissioner, directing the respondents to refund the amount along with the interest as per the sanction, the proposal of the Commission of Taxes for different assessment years and for direction of
One
vendors.
minute. So rejecting a refund proposal. 15B. Mandamus.
For 3 assessment years it is pending.
And one issue, what about that interest part? Because submission of an undertaking was there from your side.
No, I will not
Right.
beyond the undertaking.
No, because that will be another issue otherwise.
No, my lord,
You are not into that.
my lord, I am coming with a new petition where they say, in this case, I am not go beyond my undertaking.
Right.
I
Right,
not like Commission of
right.
Taxes that I give an undertaking and
Because
thereafter I say.
that can be an ancillary issue.
My lord.
That is why I have, so
Putting the respondent.
so that my mind can be
But the
framed like
respondent
in
authority
that
can
manner.
say, the earlier whatever was there, that board even issue that is illegal activity, I don't follow. I will never say, whether my undertaking which was given, is the board even issue, is it contained in
Ah.
section, I will never say.
Because this commission, or earlier commission of tax order proposal for sanctioning was of 25/10/2019,
My lord.
and your undertaking
Just a bit before immediately.
immediately. So
Because I was asked that you give undertaking.
give undertaking. So you
Yeah,
gave.
Gave, and it is, I thought that, the money will come, so let us forget about the interest for this 1 year.
So this by the undertaking, what he had asked for.
That you will get the interest only from the date of the interim order passed by the Supreme Court,
That is 2070.
17.
But so far as principal amount,
There is no dispute.
he otherwise the earlier commissioner of tax, he arrived at a final amount,
Minor.
principal amount.
Including interest, what is the amount?
Interest, what is the amount? And that later, that was
Now that amount will increase,
removed.
that amount will increase because the 10% further will be there for 3 years. 19 there, so 23, 4 are there, so
So from the interim order till realization.
we realize.
Your case is that the interest will be from the date of the interim order of the Supreme Court
Full payment.
till payment.
So if in 2019, we are in 2024.
Okay.
So
So
4 years more.
facts are more or less clear.
Now the legal issues will be there. And
Yes, Mr. Gogoi will can proceed on sound.
My lord.
Is for
Any day convenient to your lordship, my lord.
not
Only for-
convenient also, you have to be convenient.
The legal submission are yet to be made, man. And there's some factual part in the other 6 cases too.
That
What-
I will,
what- yeah.
that I will distinguish.
Slide,
how, in what manner?
otherwise, my legal issue, my lord, same, Supreme Court judgment is same, but assessment orders and all, my lord,
The
the
date
provision
is
under.
established.
Regions and
Yes,
same,
yes,
Same,
almost same,
the impugn order is same.
yes.
Similarly worded,
Yes.
Grounds are same,
The regions are the same, my lord.
acquiescence, delay,
Yes.
time barred,
My lord.
Backbenchers.
back fence sitters,
Yes.
Yes, yes.
fence sitters,
Yes, yes.
all these are same.
And not a.
Deputy Commissioner, assessment,
My lord, my lord. That part-
CST, VAT,
Yes, sir.
Same,
same.
Yes, yes.
Maybe dates may be different.
Yeah.
Only thing is that in all the other cases, whether their applications are also pending or not, we're also pending or not.
Well, that will, next I will give separate
If,
chart
if,
also.
if there is some difference, you point out.
My lord.
If that one.
Otherwise, if the facts of this case,
I understand.
sequence of events,
My lord.
and the events of the other cases are almost running parallelly,
Lordship. That will point out, my lord. But-
then only legal issues are there.
Yes.
But if suppose some vital fact that yes, their refund applications were dismissed and they were sitting,
No, my lord, that's nothing.
then after this Supreme Court judgment, they came.
There is
Then that will be different case.
not a single case where the applications were
Okay.
dismissed.
No, my lord. It has not been discussed. Yes.
তোমাক মইতো ডিছপ'জ কৰিব ৰাখি দিছোঁ না নহয়
মোৰতো জিকি গ'ল।
কোনটো পাইছোঁ ক'ত আহিব না এইটোতে আহিব পোন্ধৰ ন মিষ্টাৰ গগৈ মিষ্টাৰ ডক্টৰ স্বৰাজ can it be 15?
Lordship.
15th of February? We'll keep it for
15, there are two series. One is pending for lordship and parted matter. Number of times the time is taken by the industry department. The substantial expansion matter.
Yes, Assam looking.
we'll do it like that if the advocate general is also free. Then we'll either or we'll
I
do.
don't know.
No, no, it should be first of all me. I was not free, so then I may be allowed.
No, I will keep this that matter as well as this
No,
matter
so that-
either or
So that I may.
basis, and we'll prefer to go with this.
Yes.
These states. Then we'll take up that other one.
I will prepare comparison before that, you know. Submit the laws.
Okay, hard Dr. Sarah A. Sarah, learned counsel for the petitioners. Post of Mr. Gugoi, learned standing counsel taxation and finance department is present. As the submissions of Dr. Sarah, senior counsel for the petitioner, is not complete today. And release these cases on 15 to 2024 for further hearing. For further hearing.
Well,
Pardon.
nowadays that is the word used, you know, instead of parted because the.
No, because
Supreme
then
Court-
limitation comes in.
So the Supreme Court action, all these things, 3 months, difficulty, you know.
Dr. Saurabh, complete the further hearing. Otherwise, it will be difficult. If it comes before any other court,
There is no problem. you can-
identify that it is for further hearing, right?
We'll mention it. I'm highly obliged. Item number 15.
Mr. Das, we thought of, but we have some other works. So I thought that today you can be accommodated. Mr. Borua. Oh, no, because no, I have some,
Yes, yes, madam.
some other pressing works. Not inside the court,
Yes, yes,
outside the
madam.
court, right? So we thought that we could accommodate you, so that is why, but passing an order will be difficult again because of some other agencies. We can keep it someday else. You say that it is covered.
Covered, madam. All terms and
What's this?
conditions.
ওচৰতে Okay, we'll try to keep it on 1st of February.
Yes,
If possible, we'll
yes.
Okay. Particular নাম song. Item number. It's just N board লিখে দিব, S board লিখে দিব. Please the question. One, two.
For hearing number 10.
Yes, madam.
Your Lordship. This matter is regarding non-payment of these lordship. I am a registered society. The society deals with the collection of the rice under the two schemes. And
Yes, Mr. Borua, in 2019, Mr. J. Pigu saw time to get updated instruction.
2019.
I think non-payment, right? Non-payment.
Non-payment of
In fact, that the updated instruction.
Last order was on 23rd
Yes.
October 2019. Was there anything regarding payment?
Yes.
lordship. They filed a affidavit in opposition on 28/5/2021.
It is not in the record,
Respondent number 3 filed an affidavit in opposition.
not in the
no.
record.
15 affidavit in opposition filed a long time back. It is in 2015. There are part,
15.
yes. After that updated instruction has been sought for and which has come in. In fact, it is in 2019.
Right.
So this updated instruction set, if I can just hand it over.
Otherwise, what is the date of your instruction?
Instruction is 28/10/2019.
And then after the last order was
Because
on,
last 23rd/10. Yes.
is there anything
Yes.
positive about the petitioner?
Positive in the sense, may I read the relevant portion? Budget allocation of outstanding liabilities amount of 6,80,000 odd amount was received by so and so, but due to non-receive of ceiling, they could not be disbursed the amount. Moreover, payment for transportation cost of AAY rise has already been paid to the secretary. So this is already paid to Secretary Dhokwakhanda subdivision. In this regard, letter from Secretary Dhokwakhanda Samabay Committee is enclosed. So,
Find out that letter.
yes.
Find out from that letter, your secretary is writing something.
Hmm.
They are saying, you
Yes.
find out what he has written.
This is in vernacular. I have to read it
Yes.
out. Yes. মহোদয় সন্মান সহকাৰে আপোনাক জনাও যে ঢকুৱাখানা সমবায় সমিতি লিমিটেডৰ ইমাৰ্জেঞ্চি 2015-16 চনৰ অসম চৰকাৰৰ পৰা অন্ত্যোদয় চাউলৰ কমিশ্যন টকা আদায় নোপোৱাৰ অসম চৰকাৰৰ বিপক্ষে গুৱাহাটী উচ্চ ন্যায়ালয়ৰ ঢকুৱাখানা সমবায় সমিতি লিমিটেডৰ WPC 400 of 2015 গোচৰ তৰিছিলোঁ যদিও গোচৰ চলি থকা অৱস্থাতে অসম
800,
চৰকাৰে
800.
ঢকুৱাখানা অসম চৰকাৰ সমিতি লিমিটেডৰ অন্ত্যোদয় চাউলৰ বাবদ দিবলগীয়া কমিশ্যনৰ টকা আদায় দিছে। সেই হেতু আবেদনকাৰীয়ে উক্ত গোচৰীয়া হিচাপে অসম চৰকাৰৰ বিৰুদ্ধে গুৱাহাটী উচ্চ ন্যায়ালয়ত ৰুজু কৰা WPC ইমান নম্বৰ গোচৰটো উঠাই ল'বলৈ বিচাৰিছে।
But I have no.
Find out,
about
find
it.
out.
No, this is a
Do you
government
have any
instruction. It's a
connection with your petitioner or not?
Actually, my senior has not told me about this.
What is the date of the secretary's letter?
Secretary letter is 15/9/2019.
Secretary is writing that he has received the money.
Hmm.
Right? So take your instruction. MS and they, Learned Counsel for the petitioner, and Mr. S. Borua, Learned Junior Government of Assam for the state respondents. First of Mr. Borua has submitted that as per instructions received from the office of the covering letter. Your instruction covering letter.
Yes. Office of the Deputy Commissioner.
Office of the Deputy Commissioner, comma,
Lakhimpur. Not Lakhimpur.
not Lakhimpur. White,
White
letter number, letter dated,
NLS.
letter dated
Yes. Letter at 28/10/2019.
28/10/2019, comma, and the amount regarding transportation charges
Charges of
of AAY scheme,
rice.
rice. had already been dispersed to the petitioner society and to that effect, the secretary of the petitioner society had written a letter on
25/9/2019.
25/9/2019 endorsing the said fact of receipt
Is it?
of the amount.
And also the intention to withdraw this case.
Full stop. Record right now. You keep a photocopy in the event suppose Mr. Borua was not available on the next date, we will be in difficulty. Keep a photocopy. You keep the original with you. I just keep this on record.
Yes.
Mr. Borua may not be allotted to this court,
Maybe.
and this state council may not bring the file. Right. Mr. Borua, apni koi dibo. Apni koi try. Mr. Borua has handed over a copy of the secretary, copy of the letter of the secretary of the petitioners society to MS Day. To MS Day. Court is giving
Yes. I understand.
to enable MS Day to obtain further instructions in the matter. Right? So we can keep it on a fixed date. List the case as sought for by the by MS Day. List the case on for hearing. It was hearing or something. Did you get a head date of the hearing? 20. So first you try to get the phone number of the secretary and talk to him and ascertain whether he has written this letter or not. Then ask him whether he has received the money or not. Come back with that instruction. Court master will give you a copy of that letter.